Welcome to week 10 of Nursing 101. This is our last week of the term for lecture. This week we're going to lecture on Chapter 4, Legal and Ethical Aspects of Nursing. So let's just get started so we can get this lecture over. Remember, this is your last lecture for Nursing 101 for the term. So types of laws and examples. This is on page 33, table 4-1. You have constitutional law, which is an example of that is a right to free speech. You have statutory law, that is the creation of nurse practice acts. Administrative law is the development of state boards of nursing. Criminal law is prosecution of violation of provisions of the Nurse Practice Act, or like prosecution of malpractice. And then you have civil laws, which an example of that would be HIPAA violations of privacy. And like I said, that is on page 33, table 4-1. So terminology, and this starts on page 32. But first off, we're going to talk about what are laws. Laws are formal written rules of behavior that govern conduct and are enforced by an authority. Ethics refers to the philosophic studies that examine the actions, values, and moral principles of human behaviors and which provide the fundamental ideas of societal and cultural values of right versus wrong. So on page 32, it talks about the legal issues of nursing practice. You are held responsible for maintaining established standards of nursing care. And remember, we do encounter many situations that involve legal responsibilities. And some of the major concerns related to legal and ethical aspects of the healthcare professions are listed there on page 32, the right column. Nurse Practice Acts, nursing standards, and nursing licensure. Nursing practice and medical practice laws, there's similarities and there's differences. But the one that I know that I want you to know is the Nurse Practice Acts, nursing standards, and nursing licensures. Those are some of the major concerns related to the legal and ethical aspects of the healthcare profession. So what is a crime? A crime is a wrong committed against a person or property or public good. A crime occurs when a law is violated. So it is a deliberate commission of a forbidden act or omission of an act required by law. So in a crime, intention to do wrong is also present. Crimes can be misdemeanors or felonies. What is a felony? A felony is a serious crime. Healthcare workers can be convicted of felonies for such offenses as falsification of medical records, insurance fraud, theft of narcotics, or practicing without a license. A misdemeanor is a crime that is considered not as serious as a felony, but it is still serious and may be cause for revocation of a nursing license. So an example of that is possession of controlled substances can be considered either a misdemeanor or a felony as defined by the local, state, or federal laws. So, you know, in a hospital, all narcotics are kept double locked and every dose or tablet must be accounted for. Violation of the Controlled Substance Act is a serious crime. Liability. Liability is a legal responsibility for one's actions or failure to act appropriately. A crime may be the deliberate commission of a forbidden act or omission of an act required by law. So a nurse may be liable if a client receives a wrong medication and is harmed. That is an act of commission. Other examples of crimes of commission would be participation in an illegal abortion, participation in euthanasia, and practicing nursing without a license or beyond the legal limits of your nursing practice. A nurse may also be liable if a client did not receive a prescribed medication and was harmed. That would be an act of omission. So the client did not receive a medication they were supposed to get and they were harmed as a result. So that is an act of omission. Crimes of omission include failure to perform a prescribed treatment, failure to report child or elder abuse, and failure to report a specified communicable disease or an animal bite. Then we move on to tort. Tort is an injury that occurred because of another person's intentional or unintentional acts or failure to act. The injury can be physical, emotional, or financial. A tort involves a breach of duty that one person owes another, such as a duty of a nurse to care for a client. Examples of intentional torts are assault, battery, false imprisonment, invasion of privacy, and defamation. An example of an unintentional tort is negligence. Malpractice is defined as professional negligence. So we talk about negligence. Negligence is defined as harm done to a client as a result of neglecting duties, procedures, or ordinary precautions. It is one of the most common causes of lawsuits by healthcare clients. Negligence describes the failure to act as a reasonable person would have acted in a similar situation. It takes into account your educational level and experience. Negligence is balanced against what another nurse with similar education and experience would have done in a similar situation. A nurse can be found negligent and can be sued for damages for any of the following reasons. And this is on page 33, right column. In the middle of the page, performing nursing procedures that have not been taught. That is, these procedures a nurse can be found negligent and be sued for damages for any of these reasons. Performing nursing procedures that have not been taught, failing to follow standard protocols as defined by the facility's policy and procedure manuals, failing to report defective or malfunctioning equipment, failing to meet established standards of safe care for clients, failing to prevent injury to clients, other employees, and visitors, and failing to question a physician's order that seems incorrect. Malpractice is the improper, injurious, or faulty treatment of a client that results in illness or injury. Harm that results from a licensed person's actions or lack of actions can be called malpractice. A nurse commits malpractice when their conduct deviates from the normal or expected standard of behavior that would be performed by someone of similar education and experience in similar circumstances. Remember, healthcare professionals are held to higher standards than untrained individuals. Standards of practice are defined by the state's Nurse Practice Act. Assault. Assault is a threat or an attempt to do bodily harm, including physical or verbal intimidation. A gesture that the client may perceive as a threat is an assault if the client believes that force or injury may follow. So an example of an assault is telling a client you are going to restrain them in bed. So like I said, assault would be an example of an assault would be telling the client you're going to restrain them in bed if they try to get out of bed without assistance. That is considered an assault. Now, battery is physical contact with another person without that person's consent. Physical striking or beating is battery. Also considered battery may be touching of a person's body, clothing, chair, or bed. A charge of battery can be made even if the contact did not cause physical harm. An example of battery is giving an injection that the client refused. So the thing of it is, so, that's why to protect nurses and other healthcare individuals from charge of battery, clients sign a general permission for care and treatment. Before any special test, procedure, or surgery, clients sign another consent form, informed consent. And that I'll talk about in just a moment, but I want to refer to inferred consent means that in a life-threatening circumstance, the client would provide consent for care. Informed consent means the test, treatments, and medications have been explained to the person, as well as the outcomes, possible complications, and alternative procedures. Before any client receives routine treatment, a specialized diagnostic procedure, or an invasive procedure, or specialized medical or surgical treatment, they must give informed consent. And usually the physician explains the situation and obtains the consent. The one thing I want you as students to remember is the nursing student never serves as a witness to any legal papers or documents. So libel. Libel is a written statement or photograph that is false or damaging. And libel and slander relate to personal integrity. And like I said, libel refers to a written statement or photograph that is false or damaging. The internet and electronic communications have the potential of carrying personal conversations into the public domain. So we have to take special precautions to avoid libel when using email communications. Slander is malicious verbal statements that are false or injurious. Nurses must avoid untrue and unwise statements at all times. Slander can take the form of gossip and exaggerations such as that nurse is lazy, the supervisor doesn't know what she is doing, Dr. X's clients always have complications. Defamation is an act that harms a person's reputation and good name. Sorry about that. Abandonment of care is a legal term that implies that a healthcare professional has prematurely stopped caring for a client. To avoid charge of abandonment, you never leave your employment or clinical assignment, even in an emergency, without proper notification being given to your supervisors. Also, examples is another example, abandonment of care. If a client cannot safely be left alone, you may be found liable if the client under your care is injured while unsupervised. Another example is if a home care client has an infection or stops taking medications, you may be found liable if you fail to report this information in a timely manner. So to avoid that charge of abandonment, never leave your employment or clinical assignment, even in an emergency, without proper notification being given to your supervisors. Invasion of privacy and confidentiality are of critical legal and medical concern. The right to privacy means that a client has the right to expect that their property will be left alone. Healthcare individuals may be charged with trespassing, illegal search and seizure, or releasing private information, even if the information is true. Remember, you are violating the law if you give out any information about a client without their written consent. Always, always, always protect your client's confidentiality. The law that defines and regulates the practice of nursing in the United States is called the Nurse Practice Act. These laws define the title of nursing and regulate the many aspects of the field of nursing. The law or Nurse Practice Act in each state, province, or territory defines regulations for practical and registered nursing. Components of the Nurse Practice Act. Definition of practical and registered nursing. Nursing functions protected by the law. Requirements for an approved school of nursing. Establishment of requirements for licensure. Process and procedures for becoming licensed. Procedures for maintaining licensure and continuing education. Issue and renewal of nursing license, suspension, revocation, and reinstatement of license, and interstate endorsement. These are all components of a nurse practice. Functions of the State Board of Nursing. They have the legislative power to initiate, regulate, and enforce the provisions of the Nurse Practice Act that is delegated to a specific state agency, often known as a State Board of Nursing. Boards are subject to legal parameters, but they usually have some leeway in interpreting aspects of the Nurse Practice Act. In the recent past, the State Board of Nursing were responsible for the creation of the licensing examination. However, now they are written by the National Council of State Boards of Nursing. Precautions against lawsuits. Follow accepted procedures. Be competent in your practice. Ask for assistance. Document well. Do not give legal advice to clients. Do not accept gifts. Do not help a client prepare a will. And consider malpractice insurance policies. This information is all on page 38 and 39 of your book. Always remember, follow accepted procedures, be competent in your practice, and document well. Because remember, with careful documentation, it's probably it is the most important thing you can do to protect yourself against an unjustified lawsuit. If you do not document a treatment or medication, legally, the measure is considered not to have been done, and you can be held accountable. Of course, you will be held accountable for performing an illegal or negligent act, whether or not you document it. But remember, careful documentation. And always remember, competent in your practice, because ignorance is not a legal defense. Ignorance is not a legal defense. Neither is lack of sleep nor overwork. is accepted as a legal reason for carelessness about safety measures or mistakes. Always follow those accepted procedures. Protect yourself from lawsuits by performing procedures as taught, and ask for assistance. Always, if you're unsure how to perform a procedure, do not assume responsibilities beyond those of your level. And as always, question any physician's order that you do not understand, cannot read, or in which you believe an error occurs. The Good Samaritan Act. The Good Samaritan Act is effective in most states. It protects a person from liability if they give emergency care within the limits of first aid, and if they act in a reasonable and prudent manner. On page, I'm trying to find it here. Of course, now that I'm looking for it, I can't find it. But let's see. I will tell you what page number that is on. Of course, my papers don't want to flip the way I want to. It is on page 39 of the book. And they have, they talk about the Good Samaritan Act. So read up on that. Professional boundaries. This is on page 40. Power versus vulnerability. Do not exploit the power to access private client information. Boundary crossings. Any questionable behavior should be brief, unintentional, and not repeated. Evaluate any such incidents immediately if they occur. Boundary violations. Excessive personal disclosure or asking clients to keep secrets are an example of boundary violations. And professional sexual misconduct. Seductive, sexual, demeaning, or harassing behavior is illegal and is a breach of the trust placed in you. We'll go back to the slide. And a living will is a written and legally witnessed document that requests no extraordinary measures to be taken to save a person's life in the event of a terminal illness. The living will goes into effect only if the person becomes unable to make his or her own decisions regarding care. A living will does not automatically expire in a certain length of time. A living will does not automatically expire in a certain length of time. It is in effect until the individual changes it or revokes it. Physicians and nurses are bound by the person's wishes. A directive to healthcare providers or directive to physicians is another type of written document that can be used for terminally ill adults who have no other person to name as their agent for making healthcare decisions. The physician must also agree in writing to accept this responsibility. So with a directive to healthcare providers, the person directs the physician to be their decision maker. Durable power of attorney for healthcare. That is a written document where the client names another person to make healthcare decisions should the client become unable to do so. The designated person does not need to be a relative, but individuals should discuss their durable power of attorney in advance with those they wish to designate as their decision makers. And then the Mental Health Advance Declaration establishes specific guidelines for psychiatric care. Even if the person who refuses these treatments is committed as mentally ill or mentally ill and dangerous, these treatments may not be given without a specific court order. Deficient or harmful care or vulnerable persons. People who are vulnerable to deficient or harmful care include children and some adults, mentally incompetent or confused persons, elderly people, and people living in isolation. The law protects vulnerable persons from injury, abuse, or neglect while receiving care in a healthcare facility, nursing home, school, or their own home. So just remember, children are considered vulnerable. Reporting suspected child abuse or vulnerable adult abuse is mandatory in the United States. So the law protects, it does protect vulnerable persons from injury, abuse, or neglect while receiving care in a healthcare facility. And definitions of death. We have brain death, and we have there's clinical death, or legal death, or biological death. There's two definitions. Brain death. Brain death is cessation of breathing after artificial ventilation is discontinued, cessation of a heartbeat without external stimuli, unresponsiveness to external stimuli, complete absence of cephalic reflexes, pupils are fixed and dilated, and brain death is irreversible cessation of all functions of the brain. This is all on page 41. But on page 41, it explains the difference between clinical or biological death, and it explains brain death. So brain death is also termed to be an irreversible coma. Some individuals have a condition that they call vegetative state or permanent vegetative state, and these individuals may also be considered brain dead, even though some types of brain wave functions are seen on an EEG. Papers don't want to flip today. And there are exceptions, though, that involve the determination of death. There are exceptions, and these are listed on page 42. The exceptions are marked hypothermia, where their core body temperature is below 90, such as might follow a near drowning episode, or severe depression of the central nervous system, such as after a drug overdose, with a CNS depression, such as a barbiturate. So with drowning victims, you want to make sure their body is rewarmed before you can clarify, a patient's death. So if they are a drowning victim and they are suffering from, or a patient that is suffering from hypothermia, you need to get them rewarmed to body temperature before you can legally declare them dead. Ethical issues in treatment, organ transplant. Organ transplants, There's a lot of, depending on the patients, you got to talk with organ transplants. Some organs are successfully transplanted. In some cases, as a heart transplant, in a heart transplant, the donor must be pronounced legally dead before the organ can be removed. But to keep the organ at its healthiest, however, it must be recovered at the moment the donor is pronounced clinically dead. In most cases, circulation and ventilation are artificially maintained until the organ is removed. So these situations involve issues as defining clinical death and informed consent. Organ donation is a difficult decision for families to make. So the person that talks to them, especially nurses usually nurses, the chaplain, sometimes the physicians who talk to the family members about, if they want one of their family members to be an organ donor, they attend a lot of different classes because there's a special way that you have to approach families on this. And criteria and questions. A lot of questions that families have is, why should this client receive an organ and not another client? Who will pay for the treatment? Who should receive it? There's many questions and factors that influence the decisions to give or withhold treatment. And so there's a lot of legal and ethical considerations that may be considered as part of the criteria. And organ donations can cost hundreds of thousands of dollars, and who should have the responsibility for paying for the surgery as well as long-term care of the client? Refusal of treatment. Can a client legally refuse treatment? Under what circumstances does the client lose the right to refuse treatment? Or should treatment be given even against a person's will? If the healthcare team makes a decision to provide treatment, it's called benefits. If the client makes a decision, it is called autonomy. Excuse me. So if any argument among family members or doubt on the part of the healthcare team exists, treatment must be given until the case is resolved in court. Withholding treatment means denial of treatment or care because treatment has been deemed inappropriate. If a person refuses treatment and it is illegally given, the healthcare team can be charged with battery. The only time a person does not have the right to make the decision to refuse treatment is when the greater public interest would be in danger. Termination of treatment or withdrawal of treatment involves a conscious decision to stop treatment once it has been started. Stopping treatment once it has begun is often more difficult legally than is withholding treatment altogether. And euthanasia. Euthanasia was called mercy killing, and which means the deliberate taking of a person's life to put the individual out of misery. A lot of discussion and controversy has occurred over the past, recent years about assisted suicide, and the laws surrounding this ethical problem differ from state to state. And clients and their rights and responsibilities of healthcare. Clients also have rights and responsibility, and their client rights, which is on page 44. The American Hospital Association adopted a patient's Bill of Rights, which stated the rights of hospitalized individuals. The Bill of Rights are available for home care or hospice care. And there's also the Affordable Care Act of 2010 that was initiated and updated a patient's Bill of Rights with a focus on protecting clients from specific actions of the healthcare insurance industry. And client responsibilities. Clients are active participants in formulating their care plan and making healthcare decisions, and have a responsibility to participate in and cooperate with the care given. So our duties as a nurse is to help our clients understand their responsibilities, teach them how to enhance in their own recovery process, and assist them to attain their greatest level of health and wellness. And then this is a few pages back, the HIPAA. HIPAA is on page 35. In 1996, HIPAA was developed. It is the Health Insurance Portability and Accountability Act, HIPAA. Title II was passed and serves as a federal privacy regulation. The HIPAA Title II Act regulates who can have access to client information, sets standards for storage and transmission of client information, and requires that healthcare facilities write policies allowing clients access to their own personal health information. The client has the right to request correction of any errors. Nursing students or staff nurses will most likely be asked to sign a HIPAA confidentiality statement each year, which certifies that they are familiar with HIPAA regulations and will follow their guidelines. Violation of HIPAA privacy practices is cause for termination of employment or of student status in most facilities. That is the end of Chapter 4, which is the legal and ethical aspects of nursing. Couple points I want to make is always remember, ignorance of the law does not protect you from prosecution. Ignorance of the law does not protect you from prosecution. And also, document, because if it was not documented, it was not completed. And that is one of the most important things you can do to protect yourself against an unjustified lawsuit is your careful documentation. Have a great week. And like I said, this is the last chapter of Nursing 101.